Wyme says the Missouri law exposes people to greater harm by interfering with the federal government's ability to enforce firearms regulations.
Distribution of 10 to 40 million of these braces and the implementation of your rule. Did Congress pass a law?
Details of the law, but folks, listen at home. Here's a quick summary of what this law is doing. It's already allowing.
Wyme says the Missouri law exposes people to greater harm by interfering with the federal government's ability to enforce firearms regulations.
After lower court rulings struck down long-standing gun restrictions, the Biden administration asked justices to uphold restrictions on people with domestic violence restraining orders. Here's more. The crux. Although recent victories for the Second Amendment in the United States Supreme Court, such as New York State Rifle and Pistol Association versus Bruin 2022, may give many Americans the impression that the Second Amendment has become immune to attempts by state legislatures and Congress to violate it, the administrative state has been working behind the scenes to criminalize law-abiding gun owners. Over the last several years, the Bureau of Alcohol, Tobacco, Firearms and Explosives, or the ATF, has been bypassing Congress and abusing its power to alter the definitions of firearms within already enacted laws. For decades, gun owners have abided by these definitions as they have exercised their constitutional rights. Most recently, the ATF, without Congress's approval, changed the definitions of firearms found in the National Firearms Act of 1934. This change in definitions via the ATF's new rule specifically jeopardizes the legality of stabilizing braces, a popular accessory commonly used by millions of gun owners nationwide.
Blatantly denying the power grab being carried out by the executive branch yet again.
The uptick in violence has just been astronomical. The gun violence.
As a kid, I came out of a different movement, the civil rights movement.
Who showed up here said one thing that felt good about doing this kind of event was that they felt empowered.
Pretty clear about the extent to which this is an abuse of the Administrative Procedures Act.
Is it a difficult question to understand?
Well, I'm sure it's enormously high.
It's 36 per 100,000 people.
With it off safe, just that little bit of motion, you can hear the click.
I just felt that I needed to be able to protect myself.
The new rule, released in January, establishes subjective and vague criteria the agency will use to determine when a stabilizing brace turns one's pistol into a short-barreled rifle. The possession of a short-barreled rifle would require gun owners to either register their firearms with the federal government, turn them in to the ATF, destroy them, or make significant modifications to them. In states like Rhode Island that ban SBRs, a legal owner of a pistol with a stabilizing brace would instantly become the owner of an illegal SBR with little recourse but to get rid of the weapon simply because of an unjustified definition change by the ATF. In fact, the ATF criteria are sufficiently vague that attaching any of an overwhelming majority of stabilizing braces to a pistol will change the firearm classification to a short-barreled rifle. Gun owners who do not follow politics as closely may remain unaware of the rule and continue to use these stabilizing braces. In doing so, they could go to sleep with one type of firearm and unknowingly wake up with the same firearm that the government then deems subject to greater regulations and restrictions on ownership.
Because he doesn't care about separation of powers either.
The Texas House of Representatives just voted to impeach Texas Attorney General Ken Paxton.
How many guns has the ATF lost? I'm not sure I understand the question.
It will shoot, then it comes back forward. The rifle will then cycle and cock again.
The extent to which this is an unconstitutional violation of our Second Amendment rights. But what is also true is that it is incumbent upon the United States Congress, the House of Representatives in particular.
Wyme says the Missouri law exposes people to greater harm by interfering with the federal government's ability to enforce firearms regulations.
Without a single vote by Congress, the ATF is changing the law and turning millions of innocent, non-violent, and lawful gun owners into felons and leaving affected gun owners few options besides registration or confiscation of their arms. If this kind of behavior by federal agencies remains uncontested, the significance of previous victories and future battles to defend the Second Amendment in both the courts and legislatures will be severely diminished. regulations on short-barreled rifles. As the first enactment of federal gun control, the National Firearms Act of 1934 was marketed to the public as a response to the national crime wave gripping America during the Great Depression. The NFA imposed a tax on the making and transfer of certain types of firearms, including what is known today as short-barreled rifles, or SBRs, and short-barreled shotguns, or SBSs, as well as mash guns, mufflers, and silencers.
And having to tell her that other 9-year-olds were just killed in a shooting is horrific.
And so when you keep going forward like this, it has to go through the 7 cycles of fire.
Get on the ground now!
I'm a federal agent.
917-110-3.
I'm a federal agent.
Get on the ground!
Real background checks could stop a lot of illegal guns going in different places in the country.
This shall not be infringed, and the word infringe means by banning parts on firearms actually is against the Constitution.
Until the ATF's current attempt at changing definitions, the NFA and Gun Control Act of 1968 defined short-barreled as a rifle having a barrel less than 16 inches in length, and a weapon made from a rifle if such weapon, as modified, has an overall length of fewer than 26 inches, or a barrel or barrels of less than 16 inches in length. Originally, the NFA sought to regulate handguns as stringent as mash guns, the latter being of interest because of their use by organized crime. Sawed-off shotguns were another weapon used by gangsters and common criminals at the time, justifying their inclusion alongside handguns and mash guns on the list of regulated weapons. Although SBSs were among the list of original NFA items, SBRs were only added to an updated version of the bill based on one committee member's misunderstanding of the bill. This member believed such an addition was necessary in order to prevent traditional hunting rifles from falling under the definition of those firearms affected by the NFA's restrictions.
It takes extraordinary courage for them to stand up here and retell the story.
Anti-gunners put in there to keep the guns out of the hands of lawful citizens in New York State.
It had no difference to this guy. Straight up, this guy was evil. I mean, he committed murder.
Affect us here, and it was such a breath of fresh air for the Second Amendment people.
Despite the removal of handguns from the final version of the NFA when enacted, neither SBRs nor SBSs were removed from the NFA and remained under its authority to this day. Stabilizing brace, aka pistol brace. A stabilizing brace is an accessory that can be attached to the end of a pistol. Stabilizing braces are designed, intended, and made to wrap around a shooter's forearm with the purpose of making use of the pistol more comfortable, accurate, and safe. Most braces are designed with 2 flaps made of plastic, elastic, or similar material. This design allows the brace to wrap itself around the forearm securely, and the brace is typically located above or next to the shooter's forearm while in use. Stabilizing braces have significantly grown in popularity among disabled and non-disabled shooters alike in recent years. The ATF estimates that 3 million stabilizing braces and firearms are equipped with stabilizing braces. Additionally, the Congressional Research Service, in a recent report on stabilizing braces, acknowledged,
June of 2021, you changed the department's asylum rules so that it could apply to individuals with significant gang violence.
59 times, and then, harmed a bunch of other people, 500 and something.
Most apparent here a defense of the Second Amendment, which this most certainly is.
Weim says the Missouri law exposes people to greater harm by interfering with the federal government's ability to enforce firearms regulations.
Well, because he was shooting from an elevated position, he was shooting what is called plunging fire, which is down on an area.
Unofficial estimates suggest that there are between 10 and 40 million stabilizing braces and similar components already in civilian hands, either purchased as accessories or already attached to firearms made at home or at the factory. It should be noted that the attachment of a stabilizing brace to a pistol does not increase the lethality of the rounds fired or the pistol's rate of fire. Indeed, the attachment of a stabilizing brace increases the overall weight and size of a pistol it attaches to, making the firearm more difficult to conceal. In November 2012, the ATF determined that the attachment of a stabilizing brace to a pistol does not reclassify the firearm as an SBR under the NFA. In 2014, responding to questions of whether shouldering a pistol with an attached stabilizing brace reclassified it as an SBR, the ATF issued a letter addressing those concerns. The ATF letter explained that shouldering a pistol with an attached stabilizing brace did not change the design or intent of the stabilizing brace. Shouldering the pistol with an attached stabilizing brace would not make the pistol a more regulated SBR or SBS, enforceable under the NFA. In 2015, however, after 4 years of gun owners purchasing and attaching stabilizing braces to their pistols, the ATF contradicted their previous statements in a third letter, asserting that the mere act of shouldering a pistol attached with a stabilizing brace, despite being designed and intended to be fired with one hand, redesigns the pistol into a firearm regulated by the NFA. Just months after issuing this third letter, the ATF approved the building of stabilizing braces with the capability to adjust their position, length of pull on handguns to make the use of a brace more comfortable for individuals of all different body types and builds.
We can expect in the future that more people will be carrying handguns on the streets in places like Los Angeles, Boston, and New York City.
As many of you out there, either parents, relatives, and/or victims yourself,
to do anything about what the president is doing to exercise that authority unconstitutionally, as was the case with student loans.
Because people buy hundreds of guns legally and then they sell them illegally.
In 2017, the ATF issued one more letter, resolving the confusion and legal complications generated by the agency in 2015. The agency walked back the implications of their 2015 letter that incidental, sporadic, or situational use of an arm brace would constitute a redesign of a firearm. The gun owners would no longer have concerns that a brace's contact with one of their shoulders could redesign the firearm, changing its classification to an SBR. Importance of these letters. On June 10, 2021, the Department of Justice released a draft of its new rule affecting pistols with stabilizing braces. Titled Factoring Criteria for Firearms with Attached Stabilizing Braces, this rule would contradict previous ATF approval of stabilizing braces and, under new definitions or interpretations of existing law, reclassify pistols with an attached stabilizing brace as SBRs, SBSs. During the comment period following its publication, the first version of this rule received an overwhelmingly negative response. Over 217,000 comments of the roughly 237,000 submitted were opposed, in whole or in part, to what was contained in the proposed rule. On January 13, 2023, the ATF released the final version of its new rule on stabilizing braces, officially publishing it in the Federal Register on January 31. The first version of the rule, which was open to comments from the public, contained a worksheet and point system for gun owners, dealers, and manufacturers to determine if their stabilizing braces would reclassify their pistols as SBRs. The point system received heavy criticism from the public for how easily any stabilizing brace could receive 4 or more points, which is the number required for the pistol and attached brace to be classified as an SBR. It also generated more questions than answers based on the criteria and confusing word choices used throughout the worksheet. After receiving complaints regarding the ambiguous criteria included in the worksheet and point system, the final rule removed the worksheet and point system,
Inventing the pistol stabilizing brace to help his friend, a disabled combat veteran, at the shooting range.
You gave testimony that the brave ATF agents are the ones showing up at 2 in the morning after a burglary.
Do any of my colleagues on the other side of the aisle give a whit about separation of powers?
Connecticut delegation, which is incredible. I think on this issue and many others, you're the best delegation in the United States.
No guns were lost. They were stolen by an individual who's now in prison.
And of course, we've got a lot of criticism over this. So why is it not a machine gun?
In areas that are poor, mostly minority, there's a mass shooting.
Congress wants to change the law and come up with a new interpretation, then ATF will follow that new interpretation.
However, the final rule made clear that the ATF and its agents will still use vague, subjective, and ambiguous criteria to determine if a stabilizing brace turns one's pistol into an SBR. The criteria include weight and/or length of the firearm, length of pull, surface area, the manufacturer's direct and indirect marketing and promotional materials indicating the intended use of the weapon, and information demonstrating the likely use of the weapon in the general community. To be clear, nothing in the ATF's criteria clearly establishes an existing stabilizing brace, not even a hypothetical version, that would not reclassify a pistol as an SBR. NYSRPA versus Bruin. The Supreme Court has overturned a New York gun safety law, stating that it is unconstitutional. The decision is similar to laws in 7 other states, which account for over a quarter of the U.S. population. The Bruin decision threatens other gun safety laws, as Maryland suspended a similar law just 2 weeks after the ruling. The case involved plaintiffs challenging the 100-year-old New York State handgun licensing law, which required individuals to show proper cause before they can be licensed to carry a concealed weapon in public. The League of Women Voters of the United States, along with the Leagues of Women Voters of New York and Florida, filed an amicus brief in Bruin, highlighting polling places as sensitive places where firearm restrictions are necessary. The right to vote is meaningless without the right to vote safely, and the presence of firearms in these spaces is an inherent threat to public safety. The court's decision altered the well-established test for evaluating gun safety laws, putting similar laws at risk in multiple states. After Heller, most gun laws were upheld based on a 2-part test asking whether the regulated conduct was protected by the Second Amendment, and if it was, whether the state's reasons for enacting the law outweighed the burden created by the restriction. However, Bruin held that this test stretches the bounds of Heller because it gives too much discretion to state officials.
She proves you can run for office ending gun violence in the South and you can win.
AK-47 is an automatic Kalashnikov model of 1947.
You can prevent the next tragedy. You can save life. You can save families in the process.
Thought it just like, wow, it doesn't fit the definition, it doesn't fit the rulings, but we better run this up the chain.
Some months later, during an ATF audit, I was told the background check was now a non-approval.
Because they like the outcome of the policy, the banning of a piece of plastic.
The court affirmed Heller's doctrine of sensitive places, specifying that polling places fit in that category. However, the court did not define sensitive places or address other places of mass congregation, such as protests and public transportation. Future lawsuits will likely have to find similarities between modern prohibitions and historically regulated sensitive spaces to determine whether contemporary gun laws are constitutional. The dissent criticized the majority's decision in Bruin, arguing that gun violence is disproportionately borne by communities of color, particularly black communities. They noted that the New York law did not prevent the recent mass shooting in Buffalo. Justice Breyer criticized the majority's decision for making it based on insufficient evidence, refusing to consider government interests that justify a challenged gun regulation, and disputed Thomas's interpretation of the history. The dissent argued that history is just one tool the court possesses and excessively relies on it. The court's conservative supermajority moved the constitutional goalposts in Bruin, moving the constitutional goalposts in Dobbs v. Jackson Women's Health Organization. Justice Breyer pointed out that the majority in Bruin did not balance real-world interests with text and history, instead relying on historical analogs. The court invalidated New York's law and altered the future of gun regulation in the U.S. Government's Gun Regulation Review. Highlighting cert petitions that ask the court to consider, among other things, whether to revive 2 federal gun restrictions struck down by the U.S. Court of Appeals for the Fifth Circuit. Both cases arise under the federal firearms statute, 18 U.S.C. 922, enacted by Congress in 1994. Section 922 G8 criminalizes gun ownership by anyone subject to a domestic violence restraining order. Another provision enacted in 1986, Section 922-01, bars the possession or sale of any mash gun. In a mass shooting at a concert in Las Vegas in 2017, a gunman killed 58 people and wounded 500 more using semi-auto weapons equipped with bump stock devices, which transforms semi-auto rifles into fully automatic assault-style weapons. 1 year later, the Bureau of Alcohol, Tobacco, Firearms, and Explosives interpreted the definition of mash guns under federal law to include bump stocks. The challenge to the domestic violence ban comes from Zaki Rahimi of Arlington, Texas. During a public argument in 2019, Rahimi pushed his girlfriend to the ground, dragged her to his car, and slammed her against the dashboard before firing a shot in the air to scare off a bystander. A Texas state court entered a restraining order against Rahimi and revoked his handgun license. In the months that followed, Rahimi was arrested for violating the restraining order, and he was charged with threatening another woman with a gun. In 2021, police searched Rahimi's home after he was identified as a suspect in a series of shootings. They found a .45 caliber pistol, a .308 caliber rifle, pistol and rifle magazines, and ammunition. Rahimi was indicted on a charge of violating Section 922 G8. After the judge rejected his argument that the law violates the Second Amendment, he pleaded guilty and was sentenced to 73 months in prison, followed by 3 years of supervised release. On appeal, Rahimi again contended that the domestic violence ban violated his rights under the Second Amendment. The Court of Appeals initially upheld Rahimi's conviction. Soon after, however, the Supreme Court issued its landmark ruling in New York State Rifle and Pistol Association v. Bruin, which struck down New York's concealed carry law and clarified that modern restrictions on firearms, bearing no resemblance to those in place when the Constitution was ratified, likely violate the Second Amendment. That decision opened the door to new challenges to existing gun laws and regulations. The Fifth Circuit withdrew its decision in Rahimi's case and ordered a new briefing on the effect of Bruin. Earlier this year, the appeals court erased Rahimi's conviction, concluding that because there is no historical analog to firearm restrictions on domestic abusers, Section 922 G8 violates the Second Amendment.
That requirement for showing a heightened need for self-defense, that was the teeth of these permitting laws.
And within less than 15 minutes, you can walk out the front door here with a rifle or a shotgun.
American citizens in places like New Orleans and Baltimore and St. Louis begin to seek asylum in countries like Honduras and Guatemala.
I don't know if you're referring to any particular incident.
The bump stock ban was challenged by another Texan, Michael Cargill, a gun salesman and advocate in Austin. Cargill purchased 2 bump stocks in 2018 during the public comment period for ATF's proposed regulation to interpret the federal statutory definition of mash guns to include the devices. When ATF's final rule went into effect, Cargill surrendered his bump stocks to the government and went to federal court to challenge the regulation. A federal district court rejected Cargill's challenge, and a panel of 3 judges on the Fifth Circuit affirmed, but the full court granted rehearing and reversed. Over the dissent of 3 judges, 2 of whom were on the original panel that heard Cargill's case, the full Fifth Circuit ruled that ATF could not read the statutory definition of mash guns to include bump stocks. Federal law defines a mash gun as a gun that shoots multiple bullets automatically and by a single function of the trigger or any accessory that allows a gun to do so. The Court of Appeals reasoned that the text of that definition unambiguously excludes bump stocks, which leverage a rifle's recoil to rapidly depress the trigger without the shooter having to pull and release his trigger finger. But even if the definition is unclear, the Fifth Circuit concluded it should be read to exclude bump stocks under the rule of lenity, a doctrine instructing courts to construe ambiguous criminal laws. Section 922.01 carries a prison term of up to 10 years in the manner most favorable to defendants. In both United States v. Rahimi and Garland v. Cargill, the government asked the justices to weigh in. The domestic violence ban is consistent with the test the court outlined in Bruin, the government argues, because Section 922 G8 only kicks in once a court has deemed someone to be a credible threat to their partner or child, and there is a long historical practice of limiting gun ownership by people who pose a threat to the safety of others.
Get on the ground now!
I'm a federal agent.
917-110-3.
I'm a federal agent.
Get on the ground!
To run enhanced background checks on young people under 21 trying to buy a firearm.
This government can protect its own people, except for 36 out of every 100,000 for murders.
Types of disputes that would be settled by people yelling at each other, maybe engaging in a fist fight, are being settled with guns.
Likewise, the government defends ATF's interpretation of Section 922.01 as including bump stocks, which fall unambiguously within the federal definition of mash guns because the devices enable a gun to shoot multiple bullets automatically with one squeeze of the trigger. The government emphasizes that the justices previously declined to review 3 separate rulings by the U.S. Court of Appeals for the 6th, 10th, and District of Columbia circuits that rejected challenges to the bump stock regulations. Supreme Court's Gun Rights Review. One court ruled that federal law cannot bar someone from owning a gun just because that person is subject to a domestic violence restraining order. Another decided that preventing someone convicted of a nonviolent felons from owning a gun is unconstitutional. And a third found that the federal law prohibiting people under 21 from owning firearms is unlawful. One of these recent rulings by lower federal courts are the product of court decisions striking blows against long-standing federal gun restrictions that were issued by lower court judges in the past year, after the Supreme Court, in a sweeping ruling, expanded gun rights by finding for the first time that the Constitution's Second Amendment right to bear arms extends outside the home. The decision by the Supreme Court's 6-3 conservative majority has led to a flurry of challenges to long-standing laws, both federal and state, and prompted some judges to find they are unlawful under the new standard. Other judges have upheld gun restrictions, creating divisions on the law across the country. It has also led to blue states passing a new wave of gun laws in the hope that they will not fall foul of the Supreme Court's rationale. Now the issue is back on the Supreme Court's doorstep again, with the Biden administration asking the court to reverse the lower court ruling that invalidated the federal law barring people subject to domestic violence restraining orders from possessing firearms. The justices are scheduled to discuss in private whether to hear the case in what will be the first real test of how broadly the court's conservative majority wants its 2022 ruling to be interpreted. The new test the Supreme Court adopted in New York State Rifle and Pistol Association v. Bruin requires judges to focus solely on whether a law comports with a historical understanding of the Second Amendment.
I'm just inspired by the next generation. I think it's a time for a big change.
Since you rewrote the rules of asylum based on the perceived degree of violence in these countries,
Selling more guns in the last 3 weeks than we did in the last 8 months.
But for me, and for most of you, here's what it really is. It's an important first step.
When somebody bump fires, think of this as a bump fire stock and able to move.
To be clear, this wasn't based on violence. This is based on threats specifically to individuals, on gangs.
The conservative majority, in deciding Bruin, appeared concerned that lower courts had not cast a more skeptical eye on gun restrictions after the Supreme Court's previous major gun rights ruling in 2008. The immediate impact of Bruin seems to suggest that lower courts, which have tilted to the right in recent years because of the appointments made by former President Donald Trump, have received the message this time. Now we see not only more decisions more quickly, but we see decisions striking down laws not thought to raise serious Second Amendment problems in the first place, said Jake Charles, an expert on firearms law at Pepperdine University's law school. Domestic violence claims. While gun rights activists have taken aim at state and local restrictions in the aftermath of the Supreme Court ruling, a key battleground is on a series of federal restrictions that are listed in a section of law called 18 U.S. Code Section 922. One of those provisions, 922G8, concerns anyone subject to a court order in which they were found to be a threat to a domestic partner or child. Like we discussed before, Zaki Rahimi, an accused drug dealer in Texas whose partner obtained a restraining order in February 2020, is one such person. Rahimi faced state charges for the domestic assault and another assault against a different woman. He was prosecuted separately for violating the federal gun restriction law and, before the Supreme Court had issued its new gun rights ruling, argued that the case should be dismissed because of his Second Amendment right to bear arms. A federal judge rejected the claim, noting that the law had previously been upheld. On appeal, the Fifth U.S. Circuit Court of Appeals in New Orleans initially reached the same conclusion. Then, the Supreme Court issued the Bruin decision. As a result, the appeals court heard additional briefing and abruptly changed course, ruling in March that because of the expansion of gun rights, the law fails to pass constitutional muster. It is Rahimi's case the Biden administration has asked the Supreme Court to hear, with Solicitor General Elizabeth Prelogar saying in court papers that the appeals court's ruling was profoundly mistaken. The decision threatens grave harm for victims of domestic violence, she said. Even under the Bruin standard, the law should be upheld, Prelogar said, because there is a long history of the government disarming people who are a danger to others. Meanwhile, challenges to other provisions of federal law are gathering steam in lower courts. Earlier this month, the Third U.S. Circuit Court of Appeals in Philadelphia targeted another provision, 922G1, that prohibits felons from possessing guns. The court ruled that the law was unconstitutional as applied to people convicted of nonviolent crimes. In reaching that conclusion, the court said there was no historical tradition of people being disarmed after being convicted of nonviolent crimes. Other rulings on different provisions, including ones prohibiting people under felony indictment and users of illegal drugs from possessing firearms, have followed a similar pattern. Federal gun laws targeted. Since the Supreme Court's Bruin ruling, judges have ruled in favor of challenges to many long-standing federal gun restrictions under 18 U.S.C. 922. People under 21 922b1 and related provisions. A judge in Virginia ruled in favor of a challenge to a law preventing people under 21 from buying guns. Nonviolent felons 922g1. A Philadelphia-based appeals court said that a law prohibiting felons from possessing guns could not be applied to nonviolent felons. Drug users 922g3. A court in Texas ruled that a prohibition on illegal users of drugs possessing a firearm violated the Second Amendment. Domestic violence offenders 922g8. A New Orleans-based appeals court ruled that a law barring people bound by a domestic violence protection order is unconstitutional. Firearm serial numbers 922K. A court in West Virginia ruled that a bar on guns that have had serial numbers removed is unconstitutional. People under indictment 922N. In several cases, including one in Texas, judges have ruled that people under felony indictment cannot be barred from owning a gun. Because the Bruin case had produced such varying outcomes in lower courts, it is universally agreed upon that the Supreme Court ought to hear the Rahimi case. This is the consensus of proponents of both gun control and gun rights. We would be thrilled to get further clarification from the court on these issues, said William Sack, a lawyer with the Firearms Policy Coalition, a group that advocates for the right to bear arms. Those who advocate for stricter gun control are keeping their fingers crossed that a majority of the Supreme Court would preserve time-honored regulations, such as the one that is currently being challenged in the Rahimi case. In order to avoid having to overrule the Bruin decision, the court would have to determine that the restrictions in question are in line with how the Second Amendment has traditionally been interpreted. Gaining the support of Chief Justice John Roberts and Justice Brett Kavanaugh is likely necessary for success on this front. Although both Roberts and Kavanaugh were members of the conservative majority of the court in the Bruin case, Kavanaugh submitted a separate, concurring opinion that was joined by Roberts. In this opinion, Kavanaugh described what he called the limits of the court's decision, making it apparent that the Second Amendment does allow for gun regulations. Roberts joined Kavanaugh in this position. Kavanaugh, referring to earlier court rulings, singled out the limitation on the possession of firearms by felons and those with mental conditions as an example of a rule that was not in jeopardy of being overturned. If you total up the votes, it becomes clear that both of them, Roberts and Kavanaugh, combined were required for the majority. I think everything they said will guide them when they are looking at the next case, said Janet Carter, a lawyer who works for Everytown for Gun Safety, an organization that advocates for the regulation of firearms.
I don't really see the purpose of letting other people that don't really know what harm they can do.
You specifically said that.
But I said...
What does mandatory mean?
I'm trying to say that...
Does it mean that prosecutors get a choice?
I would expect to see in the coming months and years is a lot of focus on whether or not enough places are deemed sensitive right now.
The Attorney General himself, Ken Paxton, tweeted saying, quote, "What we just witnessed is illegal."
Landmark gun ruling sparks battles. Democratic-controlled states that have lost their ability to restrict citizens' ability to carry concealed weapons in public are seeking for more means to limit public access to firearms. As soon as the monumental Second Amendment verdict was handed down by the Supreme Court a week ago, Democratic-led jurisdictions immediately began scurrying to discover new ways to limit the availability of guns in public. According to the decision, rules that violate the Second and 14th Amendments by forcing applicants for concealed carry licenses to prove they have a special need for self-defense are unconstitutional. The sweeping amendment overturns a legislation that was originally passed in New York in 1913 and also appends the procedures for concealed carry in several other states.
We are not finished. We are not finished. We are not finished.
The submitted firearm brace, when attached to a firearm, does not convert that weapon to be fired from the shoulder and would not alter the classification.
Not one more! Not one more! Not one more!
Distribution of 10 to 40 million of these braces and the implementation of your rule. Did Congress pass a law?
The most serious readily provable offenses in cases where mandatory minimums are present because it's not warranted.
What changes that item that was submitted was not produced and was not the item that was marketed.
To be able to assist those that might not have full use of all of their limbs or whatever else.
So you say that the brace changed, and so you had to implement this rule.
Sensitive places doctrine was not at issue in this case and still exists.
He went on to say he looks forward to a quick resolution in the Texas Senate.
Who are prepared and carry a gun oftentimes have to make split-second decisions.
On Thursday of last week, the possibility of more people carrying concealed firearms in large counties that normally favor stricter restrictions caused a political storm that put a shadow over the historic compromise agreement that was eventually passed in the Senate later that day. On Saturday, President Joe Biden gave the bill his signature, making it official, and it promised to expand the widening rift between blue states, which generally support stricter gun policy, and red states, which normally try to preserve or loosen gun restrictions. Blue states generally favor stricter gun policy. Red states generally aim to keep or loosen gun restrictions. According to Eric Rubin, an expert on the Second Amendment who teaches at the Southern Methodist University Dedman School of Law, it will be easier to get a license. He forecasts that the number of persons in the impacted states who carry concealed pistols will increase. New York Governor Kathy Hochul called the legislature to Albany to address the change. In California, legislators started pushing forward on bills they had drafted in preparation for the Supreme Court's ruling. In Hawaii, where only 4 concealed carry permits have been issued in the last 2 decades, legislators contemplated how to preserve the state's strict policies. Meanwhile, individuals lined up outside the Honolulu Police Department to apply for concealed carry permits before new laws could take effect. The New York law previously required concealed carry applicants to demonstrate a specific need for self-defense, rather than a generalized fear of being attacked. States with similar policies, New Jersey, Massachusetts, Maryland, Rhode Island, Delaware, and California, can no longer impose that requirement, eliminating a key filter for limiting concealed carry permits. Lawmakers in the affected states, losing that tool, are now considering expanding gun-free zones to public transit infrastructure and crowded places. New York City Council Speaker Adrienne Adams expressed her intention to sponsor a resolution making the entire city a gun-free zone, but this approach conflicts with Supreme Court Justice Clarence Thomas's opinion, which states that jurisdictions cannot restrict concealed carry based solely on population size or density. The ruling is significant not only for what it says, but also for what it doesn't. Over the past few years, conservative activists have pushed for laws in several states that allow people to carry concealed handguns without applying for a license, often referred to as constitutional carry. However, the recent Supreme Court ruling left concealed carry licensing systems intact, contrary to what some legal experts anticipated. Rubin noted, they could have set permitless carry as the constitutional floor. They did not do that. Consequently, local jurisdictions still have the discretion to limit concealed carry.
Conventional wisdom was we would never get any Republicans to support gun legislation, period.
Are ones where, in fact, it's most likely that they should be bringing the highest and mandatory minimum.
Details of the law, but folks, listen at home. Here's a quick summary of what this law is doing. It's already allowing.
Demonstrating that blind loyalty to Speaker Dade Phelan is more important than upholding their oath of office.
Might end up being a message amendment because the President of the United States will almost assuredly veto it.
Even with the state law struck down, New York City maintains one of the nation's highest bars for obtaining a concealed carry permit. Applicants must navigate a lengthy process involving a 17-page application, various supporting documents, a background check, and a police interview, all before obtaining the license required to purchase a handgun. According to Arnold Wachtel of Advanced Protection Consultants, a business assisting applicants through the system, the current wait time to obtain a New York City handgun license ranges between 1 and 2 years. Only after clearing this initial hurdle can applicants proceed to apply for a concealed carry permit. In response to the ruling, legislatures in some states are already considering implementing similar requirements. Mandating education, training, exams, interviews, or enhanced background checks before issuing concealed carry permits remains constitutional. Adam Skaggs, chief counsel of the gun reform group Giffords Law Center, stated, "What those states are going to be looking at is how do you strengthen the eligibility requirements, but any and all of these things may be challenged by the gun lobby." That's all for this video, folks. We'll see you next time.